Good afternoon. My name is Dan Terris. I am Director of the International Center for Ethics, Justice, and Public Life here at Brandeis University, and it's my great pleasure to welcome you to our program today, Gideon at 50, the future of the right to counsel. 50 years ago, on this exact date, that is on March 18th, 1963, the Supreme Court of the United States issued its historic opinion in Gideon versus Wainwright. Now, it's hard for us to imagine now in 2013 that before 1963, if you were accused of a felony in a state court in this country, and you could not in many of the states, and you could not afford to pay for a lawyer, the state had no obligation to provide one for you. You simply went into court and did the best you could, defending yourself, cross-examining witnesses, and matching wits with the prosecutor. The Gideon decision changed all that. Or did it? Certainly new structures were put into place. Public defenders' offices at the state and county levels were established, and procedures were put into place to match public defenders with accused. But 50 years on, knowledgeable onlookers point to continuing deficiencies in the system. Cutbacks to public defenders' offices have taken a toll. If a defense attorney has to try 500 cases a year, can she really provide meaningful representation to all of her clients? And what about those who can't afford representation in misdemeanor trials or in civil cases? A half century onward, many questions remain about whether the promise of Gideon versus Wainwright has been fulfilled. We have an outstanding panel with us today to discuss these questions. A group of individuals distinguished not only for their achievements, but for the diversity of perspectives that they bring to this discussion. We have with us today an eyewitness to the original hearing and the author of the definitive account of the case. We have with us a justice of the Supreme Judicial Court of Massachusetts, whose experience as a judge has put her on the front lines of these issues for many years. We have with us a man who has headed the statewide public defender's office in 2 of the most important states of the country. And we have with us a former prosecutor who left the active practice of law for a rather successful career as a professor, a dean, and a university president. We're very pleased to bring you this program today as a cooperative venture between the International Center for Ethics, Justice, and Public Life and the Legal Studies program here at Brandeis University. The director of that program, Professor Richard Gaskins, sends his regards and regrets that he can't be here. He's otherwise engaged introducing Brandeis students to international justice in our Brandeis in The Hague program in the Netherlands. But he sends his greetings and very excited to hear about this program. Many thanks to the many faculty members and student groups who have pitched in on this event. I want to send a special shout out to the Brandeis Law Journal, which this evening at 8:30 p.m. is going to be screening the film of Gideon's Trumpet in the Mandel Center Auditorium. So I encourage you all to follow up the discussion with the film presentation this evening. And finally, a very special thanks to David Weinstein, my colleague in the Center for Ethics, Justice, and Public Life, who's been the principal coordinator for this event. Our program today will be a moderated discussion among the panelists, followed by a question and answer period. I'm very happy to see so many students from legal studies and related areas here today, so I expect a lively and active round of questions from Brandeis students who bring extensive knowledge and passion about civil liberties issues to this discussion. We're all eager to jump into the discussion, so with your permission, I will dispense with lengthy introductions, the lengthy introductions that each of our distinguished panelists deserves. You'll find their bios in your programs, and you can probably know how to track down more information about them on your mobile devices if you require more. So let me simply identify the members of the group, and yes, it is appropriate to greet each of them with a round of applause as I say their names. First of all, on my immediate left, the legendary journalist and the author of Gideon's Trumpet, the definitive account of this case, Mr. Anthony Lewis. To his left, the director of the New York State Office of Indigent Services and former chief of the Public Defender's Office for the Commonwealth of Massachusetts and a former faculty member in the Brandeis University Legal Studies program, Mr. William Leahy. a veteran judge who now sits on the Supreme Judicial Court of Massachusetts, Associate Justice Margot Botsford. And the aforementioned former prosecutor, legal scholar, and leader of Brandeis University, President Fred Lawrence. It's now my pleasure to turn the program over to the moderator for today's events, a gentleman who is an experienced attorney in his own right, a Brandeis alumnus of the class of 1983. Please join me in welcoming the Chief of Staff to the President of Brandeis University, Mr. David Bunis.
Thank you very much, Dan. We are going to have a lively discussion, followed by your provocative questions, and all of that in between now and 5:30. Do you have a copy of the decision in Gideon versus Wainwright? President Lawrence can correct me, but is it right to assume that everybody's read it, or?
At Brandeis, absolutely.
Yes. So let's begin class today with a brief, what I would call a brief overview of the Supreme Court's decision in Gideon versus Wainwright, before we launch into discussing the decision and its effect with our panel. In August 1961, Clarence Earl Gideon, a white man in the state of Florida, faced trial on a felony charge of breaking and entering into a pool room with intent to commit a misdemeanor therein. He was 52, and he couldn't afford a lawyer. On the date that was set for his criminal trial, Judge Robert McCrary, who was presiding over the trial, asked Gideon if he was ready for trial. It's a question that begins most every prosecution and criminal case anywhere. Gideon responded that he was not ready for trial, and he asked the court to appoint a lawyer to represent him. The judge declined and said that in the state of Florida, the only time a lawyer must be appointed was for a capital case. This wasn't a capital case, and so he would have to decline Gideon's request for counsel. The judge ordered the trial to proceed. Gideon made an opening statement. He cross-examined the prosecution's witnesses. He presented witnesses on his own behalf, and he made a closing argument. Shortly after that, the jury convicted him, and he was sentenced to 5 years in prison. He filed a timely writ of habeas corpus to the Florida Supreme Court, which denied the petition without a written opinion. And then he timely appealed to the United States Supreme Court. And the basis of his appeal, which is laid out beautifully in the first few pages of Gideon's trumpet, he makes the simple claim that his conviction was in violation of the United States Constitution and the Bill of Rights. 50 years ago today, the Supreme Court ruled in a unanimous decision authored by Justice Black that it was overruling its previous decision from 1942 in a case called Betts versus Brady. The court reversed Gideon's conviction and ruled that, and the line I'll use is the opening line of Anthony Lewis's article that he wrote in the New York Times on March 19th, the day after the decision came out. The court ruled that states must supply free lawyers to all poor persons facing serious criminal charges.